Hi, everyone. Thank you for joining us today for Constangy's webinar, Data Privacy in the Workplace, Risk, Liability, Mitigation, and Compliance. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. I'm now going to turn it over to Sean.
Good morning, and I am so pleased to have the opportunity to introduce a couple of my colleagues this morning. I am so fortunate to have the opportunity to work with them on a daily basis, and many of whom I've known for quite some time. In fact, Mr. Goldberg and I go back probably more than 30 years and our time as cyber attorneys at U.S. Department of Justice. But I'm first going to introduce Sarah Rugnetta. She's the vice chair of our practice group and leads our compliance advisory services. Sarah's a graduate of St. Lawrence University and the University at Buffalo Law School, and she's been involved full-time as a privacy attorney for over 15 years. And during that span of time, she's been a privacy officer, she's been a regulator, she served as both in-house and outside counsel, and we are so fortunate to have her on our team as a vice chair leading up our compliance advisory services. And we're excited also to join. She has 6 professionals joining her team yesterday. The additional partner, 3 additional associates, 2 paralegals, because we are the demand for our services, our compliance advisory services, have been so great in the 3.5 months that we've been here at Constangy. And so we're so glad to have Sarah here. She's going to overview some of the services that we offer and some of the personnel. And I'm also very pleased to introduce Rich Goldberg, a former colleague of mine at the United States Department of Justice, where we were both involved in the cyber attorney program. Rich is a Brown undergrad, Georgetown Law School. He's got a variety of certifications. He's currently a lecturer in law at Villanova University, where he teaches a course on legal responses to computer crime. He's also got a Harvard Wasserstein Public Fellow certification or designation a few years back for his successes. He was also recognized as part of the Fulbright Senior Specialists Program and many, many others. It's take far too long this morning for me to actually go through the accolades he's acquired throughout the years because of his, the excellence he's always provided with regard to cyber-related matters. And he's vice chair of our practice group specifically for incident response and has a substantial amount of experience over the years responding to data security incidents and managing probably over 1,000 up to this point, just personally. But he's involved full-time and we'll review some of the things we're doing in that realm and some of the trends we're seeing. And I'm also really excited to introduce Allen Sattler, a vice chair for our cyber litigation services. Allen's undergrad work was down at Syracuse, where he got his Bachelor of Science degree in Information Management and Technology, which indicates his passion for information technology, which is what he's shown to us over the years when he's been with our team as a vice chair. He also did his undergrad at St. Louis, or excuse me, his law work at St. Louis University School of Law. But he's been involved in our team now for several years and has prior experience actually doing cyber insurance related coverage work, and also was seconded in London in the London cyber insurance market for some time. So had a thorough understanding of cyber insurance, the industry, technology, and incident response. And now he's overseeing our cyber litigation work and has been very busy. In fact, I think we had 1 more class action come in last night, if I recall correctly. So I think he's overseeing at least 8 class actions with a team of tremendous class action specialists that we have here at Constangy. And with that, I'm going to sit back and I cannot wait to hear what you guys have to say about the 3 pillars of our practice group: our compliance advisory services, our incident response services, and our cyber litigation services. Ms. Sarah?
Thanks, Sean. I'm very excited to speak about our compliance advisory services today and highlight a few of the new state data privacy laws. First, I'd like to introduce everyone on our amazing team. On this slide, you'll see the Constangy Cyber Compliance Team. We're a group of privacy professionals who focus all of our time and attention on helping clients to navigate these complex and constantly evolving data privacy laws. We don't have space for bios on these slides, unfortunately, but our attorneys are former regulators, in-house counsel, business owners, and technologists. And importantly, they all have deep knowledge of data privacy and security, and this is really all we do day in and day out. On the next slide, you'll see some of our compliance services. The goal of all of our services is to help clients to reduce their risks, reduce regulatory risks, reduce the risks of incidents and litigation, and reduce reputational risks. We partner with businesses to develop a compliance strategy that's tailored to that particular business. We find practical approaches that take into account that business's needs based on their size, their industry, applicable laws, risk tolerance, and their budget. When we first meet with clients, a lot of them aren't sure where to begin in this sort of journey towards compliance and data privacy. We generally recommend starting an engagement with a gap analysis, and that service involves identifying the most relevant logs to that particular client, and then reviewing their existing privacy and cyber documentation to determine whether there are any legal or technical gaps that we should partner with them to address. Some of the areas that we've found many of our clients do need some assistance with include forward-facing disclosures to consumers, applicants, and employees about how that business collects, uses, and discloses personal information. Incident response planning is another area where we spend a lot of our attention, and we'll work with clients to draft and implement an incident response plan that's based on NIST standards. We'll then test that plan through one or more simulated incidents. Some organizations who we work with have really great administrative, technical, and physical controls that are already in place when they come to us, but they need assistance documenting those practices in formal policies and procedures. So we'll often jump in with respect to those services. We also work with clients to mitigate risk posed by vendors, which is a significant area of risk for most organizations. We'll help to develop and implement vendor management programs, which often include developing protocols around contracting, oversight, and due diligence. The next slide shows a few things. Shows a few of the new data privacy laws that we want to flag for your attention. By way of background, in the US, there's no comprehensive federal privacy law. Instead, there's federal regulations that apply to businesses in certain industries. For example, HIPAA in the healthcare industry, FERPA in the education industry, and the Gramm-Leach-Bliley Act in the financial industry. Unlike many other countries, the US has a patchwork of privacy laws and regulations, most of which are at the state level. My colleague Rich will speak a little bit about state data breach notification laws, which may apply in the event of a security incident or a data breach, depending on where the affected individuals reside. This slide focuses on the recent trend for states to pass comprehensive data privacy laws. You'll see that all of the states identified on the slide have slightly different applicability thresholds, many of which are based on the volume of data that's collected in that particular state. Today, I'm going to talk a little bit about the first tab, which is California. In California, they passed the California Consumer Privacy Act, or the CCPA, which was the first comprehensive data privacy law passed in the US. Unlike many of these other states on this slide, the California law includes a revenue threshold that brings a lot of companies, both inside and outside of California, within the scope of that law. It also has the most significant impact by far on employers, because as of January 2023, employee data is within scope of this law. This California law also applies to business data, which means that the law applies to businesses even if they don't collect data directly from a consumer. And it has a very broad definition of personal information. Unlike some of the statutes that Rich will talk about in terms of breach notification statute, it applies to any information that identifies, relates to, or could reasonably be linked to a person or household. So that means email addresses, mailing addresses, IP addresses, among other more sensitive categories of information like race, gender, sexual orientation, social security numbers, and bank account information. As I mentioned, California has a separate revenue threshold that I want to dig into just a little bit more. So it's not tied just to the volume of data collected in California. Really a for-profit business that meets that annual revenue of $25 million or more will generally need to comply with the CCPA if they're doing business in California. And that doesn't just mean being headquartered in California or have significant amount of employees in California. That really can just be marketing and selling products in California, having employees in California, recruiting applicants in California, and having vendors in California, which most businesses meet one or more of those prongs. If you want to learn more about the CCPA, my colleague Jordan Fisher and I will go into this in much greater detail during a webinar we're hosting in early June, and so I'd encourage all of you to join us for that. Finally, on the next slide. Thanks. This slide is a case study of a typical client. Constangy works with clients of all sizes, industries, locations, so it's not really easy to come up with a typical client, but this particular fact pattern is not at all unusual. This case study involves a company that has obligations under a number of industry-specific laws like HIPAA and FERPA, because they provide services on behalf of hospitals, medical providers, and schools. That means they've signed some contracts like business associate agreements required under HIPAA that include representation about compliance with these laws. The client's also required to comply with some international laws, like the General Data Protection Regulation in the European Union. And this is because they offer services to a few clients in the EU, or maybe they work with a number of independent contractors in the EU. And they've likely also signed agreements like a data processing agreement or standard contractual clauses that govern how information is shared from the EU to the US. In addition, the client has obligations under that California law we just talked about, the CCPA, because they meet that $25 million revenue and they have a few clients in California. The case study is really intended to demonstrate the complex regulatory landscape that applies to so many businesses who we work with. On its face, you might think that a client with one location in New York would not have to deal with all of these different state, federal, and international laws, but it's really not unusual when there's a lot of data being shared with other countries and other states. And oftentimes these types of obligations under different laws are pushed down by contract as well. Because they're subject to so many different laws, this particular client and so many other clients really do need to have put together a strong privacy and security program. So that's why they've brought us in to help them. Now I'm going to pass this on to my colleague Rich to talk a little bit about our incident response services. Happy to answer any questions at the end.
Thank you, Sarah. So our group is so large that we can't put all the pictures up there. We have attorneys and paralegals everywhere in the United States. What you see pictured here are the three vice chairs, my colleague Lindsay and Alyssa, but we also have Alan and Sean, who have vast experience in incident response, and they are on the West Coast. So we really make sure that we are there to answer the phone or the email, whatever reach out is made to us, whenever it is made to us, because we know how emergent these incidents are, and then we can respond with people in the same time zone if that's necessary. But most importantly, we want to get help to you. Our team is a very experienced team. Even though we are so large, we have been able to stock the team with attorneys who have been responding to emergencies and dealing with crises for years and years. We generally have partners on every matter who have spent years in data privacy and years before that dealing with client crises, so that we know when we get on the phone with you, what you need is somebody who is going to make things better. That includes former federal prosecutors, former FBI agent, former healthcare litigators, pretty much covering every section of the American economy that might need an experienced attorney. We are emergency responders. So what that means is with us, we are ready for you whenever you call. As you can see on the screen here, there is more than one kind of cyber incident. Ransomware gets an awful lot of play, but there's business email compromise and payment redirect that is a much more low-level scheme, but is remarkably resilient and persistent. Simply an unauthorized person getting access to your system at a time that they're not authorized to do so. Credit card theft, obviously, we all know about. I can't even count how many times my credit cards have been replaced. And data theft and loss can simply be rogue employees. The result of all this frequently are government investigations. And as you've heard, we have an awful lot of government personnel here. We're very used to dealing with investigating agencies and can help you in dealing with them and resolving the concerns that those agencies might have. Last, as to insurance coverage, as you can see, if you have cyber insurance, I recommend that you get it. If you don't, we work with the insurance companies that provide that cyber coverage. The last thing that I'll say about this team is that the number of matters that are handled by your lawyer when you get on the phone matter. We see what is happening in the cyberspace every day. We're not a firm that handles 3 or 4 matters a year, and we don't have lawyers that handle 3 or 4 matters a year. We are seeing what the tactics are of the bad guys as they are developing them. We have been down this road before, no matter what your company is dealing with, and we can provide you with a slate of options as to how to deal with it that will best protect your company's reputation and limit liability. So on the next slide, this just gives you a little bit of an overview of who we work for and the diversity of the organizations that we work for, because it's not just, we do a lot of corporations. Some of them are gigantic and worldwide, and some of them are tiny. If you have a problem, we're there. That means nationwide healthcare systems to individual doctors. We are in the client services industry and frankly, the crime victim services industry. So that we want to get you back up to operating, deal with your legal requirements as quickly and cheaply as possible. We have dealt with all of these organizations, colleges and universities, government agencies. They have computers too. And even though they're not supposed to have data issues, they do. Some of them are big, and some of them are your county tax collector or your local police department. We have an awful lot of clients who are law firms. Law firms are obviously supposed to keep information confidential, and so when their data gets out and is roaming around, they become very concerned about it and are sensitive to the concerns of their clients, and we help them deal with those. Tech and web hosting organizations obviously are moving a lot of organizations' data all at the same time. So when they're hit, and the bad guys know this, you're not just hitting one company, you may be hitting 100 companies all at the same time. That's not an accident on their part. And last, the publicly regulated and publicly held companies. If you trade on a stock exchange, you have an obligation to provide disclosure. The SEC has taken a pretty hard line on the obligation of companies to provide information to their investors so that they know that an incident like we deal with has happened. On the next slide, let me just give you a small sampling of what it's like when an incident happens. Hopefully nobody on this webinar has had one. we basically come into a house that's on fire. Maybe it's a lower level problem because it happened a few weeks ago and we're trying to figure out how to resolve it, or it may have happened someplace else. It may be your upstream provider or your accountant or somebody you provided the data to who lost the data. But sometimes you've got 5,000 employees who switch their computers on and all that comes up are blue screens. That's a house that's on fire. And that's why we are a firm that will respond in minutes, not hours. We're not going to tell you that, oh, yeah, we'll get back to you sooner or later. We're there because we know how important this is. There isn't a single business that doesn't have clients or customers and suppliers who are depending on them every day to be there when they call or when they send an email. We've got to get you back up and running. We also need to find out what happened, mostly so we can figure out how to limit liability for the company. So the first thing that we're going to do is get you involved with experienced forensic firms that we work with all the time, who are going to work with your information technology people, whether they're in-house or other vendors. We can get boots on the ground there to help you. A lot of times there's a lot of work to be done to get data restored. That may be more than a particular organization can handle. We can get additional people there. We can figure out what happened and what data might have been involved. And if necessary, that may mean talking to the attackers. Seems unpleasant, frequently is unpleasant, but we're very experienced in doing it and doing it in a way that benefits your organization, whether or not a ransom is paid. And then we have to, once we get you back up and running, we've managed your clients and suppliers and your employees. We've reassured everybody, we've gotten the system secure, you're back up and running again. Unfortunately, that typically isn't the end if there's been access to sensitive data. Every state regulates sensitive data, and because it's the United States, it means we have to do it 50 different ways at least. And our job is to make sure you're in compliance with all the requirements of the 50 states. And some organizations think that they're just in one state and that's all they have to deal with. The problem is that the relevant law is where the potentially affected person lives. So you know what people are like when they retire, they move everywhere. So you may think you have no problem outside of your particular state. It turns out there are a lot of laws that may apply. That's our job to take care of that. And we get those notifications done. We deal with the regulators. We talk to law enforcement about a particular incident. Basically managing your reputation with you and managing the liability. And if there is going to be some kind of regulatory investigation that goes on, we respond to those all the time. We deal with the regulators. We know what they're looking for, manage the risk there. If there is going to be some kind of litigation that follows, and after all, when you notify people, they can get upset about it and they can think that this is some terrible disgrace. And so they want to take some kind of action against you and get paid some money. So as Alan will talk to you in a little bit, class action has become a regular feature of the landscape here. So we have to recognize that and plan for it as we're responding to the incident and getting you back up and running. So let's talk about some trends. Class actions are up and class sizes are down. It used to be that if you your notification population was under 50,000 people, that the odds were nobody was going to pay attention to you and you didn't have to worry about that. Unfortunately, the class size has gotten smaller, so that even in a small, what we would call a small notification, a couple thousand people, you might get a class action filed simply to get some kind of quick payout. I have a pretty low opinion of those actors who engage in that kind of litigation, particularly when the company has already provided the statutorily required protection to everybody. But as you know, anybody can be sued for anything. So you have to be planned for that, prepare for it, and have experienced class action counsel who knows how to deal with that and resolve the situation quickly. Nobody who's on this webinar is in business to deal with their cybersecurity. You're all doing something other than that to service your clients, and we want you to stay focused on that. The defenses by American companies have gotten much better, so that frequently when companies are hit, they can now restore from backup, which is great because it means we don't have to pay the attackers for a decryptor. The attackers have figured that out, and so they don't just encrypt computers, they also steal data, and they hold that data for ransom, and they say, if you don't pay us, we're going to publish the data. That means that clients now have a different decision to make. It's not just how to get your computers up and running. It's, is this going to embarrass our company? Is this going to affect our clients such that they'll leave us? And hopefully not also, is this going to expose our intellectual property? Those are all different concerns. You need experienced counsel to deal with them and tell you what the pros and cons are. Some ransoms do get paid because they need to be paid. And we can help companies do that and do it legally if that's what's required. The bottom line on all of this is that experience counts in dealing with these issues. It's a little bit like surgery. You don't just operate because why not? You know, odds are nothing bad's going to happen. In this area, bad things can happen. And so you want to do the notification that's required and not more. You want to pay a ransom if you have to pay a ransom, but not if you don't have to. And we can explain to clients in situations like this the pros and cons of the different tactical decisions that a company may make. And that leads to the last bullet on this slide, which is regulatory action. The regulatory environment has changed a little bit. I think the sense of the regulators is that people are paying more attention to their data, so they're going to pay more attention to the data. When there are incidents, it used to be that regulators would treat companies like they were crime victims, which is rational because they are crime victims. Nobody authorizes a company to have somebody from Eastern Europe come in and take all their data. So you're a crime victim, you should be treated with sympathy. That's somewhat changed. The companies are now being treated less as crime victims, but as companies that should have done better. Frankly, I think that's absurd, given the number of data security incidents and the number of them that are caused by activity that they have absolutely no control over. And yet regulators have taken additional action. And again, you need to deal with them with both experience in dealing with them and knowing how to talk to them so that they have a minimal impact on your business as a result of the incident. Let me take a minute to talk about some case studies. We do, as I mentioned to you before, we do every kind of incident, from the solo medical practitioner to the huge companies. With a solo medical practitioner, sometimes those doctors, dentists, therapists, they didn't even have the incident. It happened at their electronic medical records provider. And yet they are still going to deal with HHS and OCR. And of course, none of them are in business to deal with HHS. They spend most of their time trying to treat patients and keep the practice up and running, and that does not include dealing with HHS. So that's our job. I've certainly had many doctors and dentists who have an employee who decides that they just don't like working there anymore, and they're going to burn the place down on the way out in a data theft metaphor. So that has to be dealt with, not the doctor's fault. But we are going to have to deal with HHS. Again, we want to have as small a footprint on that practice as possible. Internet service providers, they can be really mom and pop shops, and yet they have 30 or 50 customers. Those customers' data is all at issue sometimes. And we have to look at what their contractual obligations are. You know, what did we promise each client of ours when we provided them internet service? And that's, those contracts increasingly apply across the board to companies. As cyber incidents become more numerous, companies realize that they need to have something built into the contract that says, hey, you have to tell me when you have a cyber incident. That's our job, to figure out whether or not the contract requires notification, and then advise you on what you're required to do and what you might want to do voluntarily in order to protect the reputation of the company. Nobody knows your business better than you do, and your clients and your suppliers and your employees. So our job is to help you get done what you want to get done while you're responding to this incident. And last, of course, are the giant companies. They may be involved not just in the 50 US different state data privacy laws, but in SEC requirements, Gramm-Leach-Bliley, GDPR. Every country on earth, not every, but pretty much all the ones where these companies are doing business, they all have their data privacy laws. And we work regularly with partners all around the world to make sure that companies can respond in the particular jurisdiction that they're in if they have to, in order to minimize liability for those companies, make sure they stay clear of regulators, protect employees, et cetera, et cetera. It's all about getting companies back up on their feet and help them deal with issues that they didn't go into business to do, but now they have it dumped in their lap. Who is going to help me solve this problem? And that's what we're here for. And that is incident response in a nutshell. Hopefully you don't wind up in a class action, but if you do, I know the guy to call. And over to you.
Thank you, Rich. That would be me. So my name's Allen Sattler. I know Sean did an excellent job of introducing all of us, including myself, a few minutes ago. But I'll dive a little bit more into my background because it relates to the topic of discussion, that being cybersecurity litigation. I began practice in about 2007 in New York City, where I worked for a fairly large firm in their litigation and arbitration department, where I litigated high exposure coverage related matters, and I arbitrated high exposure reinsurance arbitrations. So that's really where I cut my teeth in terms of litigation and arbitration experience. In 2013, I had the good fortune of being seconded with a large Lloyd's syndicate in London for about 6 months. And during that time, I worked with that company who was selling for their first time a cyber insurance policy. So I really got on the ground floor with them on that. And I used that transition to essentially become a cyber breach lawyer, first on the coverage and claims monitoring side. So from about 2013, that has really been the focus of my practice. I met Sean and others on his team in about 2017, 2018. In fact, I was on the coverage side at the time, and working with different insurance companies who offered cyber insurance policies, I would engage with Sean as breach coach, as incident response counsel. And I just loved working with him. We kept in touch over the years. Finally, in 2019, he approached me and asked if I wanted to join his team and help build. And I jumped at the opportunity. At that time, I was living in California. I moved from New York to California, so I'm licensed in both states. But I represent clients and companies nationwide. I think I've had probably a little over 1,000 incidents that I've responded to in the past about 4 or 5 years. And so what I want to mention, or one of the things I want to mention about all of this is, and Sean alluded to it as well, I have a background in information management and technology. I really, for years tried to find the intersection of the practice of law and technology. And really, what better than cybersecurity and data privacy? I think it is one of the few, if not the only, practice of laws where you can, kind of marry the two concepts, the two passions. And we really are, it's not just myself, we really as a team are passionate about this work. I mean, I think that's one of the things that sets us apart from many others in the business. Sean and Rich in particular have just a fantastic, work experience together with cybersecurity in general, but also with representing and defending victims of cybercrime. And it's personally rewarding being in that space and helping people out. And in terms of cybersecurity litigation and third-party claims, in many ways, including certain regulatory investigations and penalties, in many ways, like Rich explained, it feels as though our clients are being re-victimized after having already been the victim of an incident. And so we have a lot of compassion for them, and we are eager to help them through this matter in the most efficient way possible and in the quickest way possible so they can get back to their ordinary business. On this slide, you'll see sort of the team that I have helped to assemble in about the 3.5 months that we have been here at Constangy. And I can say in that short period of time, we've just had a tremendous reception in terms of the news of joining, this new team, this new platform. In terms of, client and insurer support has just been tremendous. In that short period of time, we have just about over 10 matters that are either pre-litigation or in litigation. We are representing clients who have cases filed in 8 different states. That being Massachusetts, Pennsylvania, South Carolina, Florida, Tennessee, Illinois, Missouri, California. And this is all in a short period of time, like I said, 3.5 months. All together, we have 11 people, that includes myself, at Constangy, attorneys who are assisting with pre-litigation and litigation. And the 4 people on this slide are really the people who have proven to be, leaders in this space. That includes Laura Balson and Ashley Orler, who are both located in our firm's Chicago office. Laura is an experienced litigator handling employment disputes, wage and hour class actions involving BIPA. She's licensed in Illinois, Maine, Massachusetts, and Wisconsin. She's also the managing partner of the firm's Chicago office. I'm not sure if I mentioned that already. Ashley Orler likewise has experience with BIPA litigation, which if people are familiar with BIPA, that does involve privacy rights and essentially alleged privacy violations to the extent that their biometric data has been disclosed without consent. Ashley is licensed in Illinois and Michigan. And finally, David Udelson. The slide indicates that he's located in Chicago, but in fact, he's located in California, in Los Angeles, near me. Although he got his start in Nebraska. So he is licensed in both Nebraska and California. And he has practiced his entire career as a litigator. And in fact, he is co-chair of the firm's ERISA practice group, where he has handled several class actions. So I work with them and with other attorneys at the firm to defend companies throughout the nation. And like I said, in the short 3.5 months that we've been with Constangy, we've just had tremendous growth. It's been really exciting. I want to identify and name the other attorneys at Constangy, even though they don't dedicate their practice to cybersecurity like I do. They've been great in working with us, either in the capacity as local counsel or making various appearances. In one such matter, we've already worked to resolve it. We got a settlement. The settlement was executed and paid. The case was just dismissed earlier this week. So those people are Angelique Lyons, she's a partner in Florida, Christopher Dubert in Massachusetts, Kara Crotty in South Carolina, Zam Blue in Tennessee. And finally, we have 3 great associates who've been helping us: Katie Roten in St. Louis, Missouri, Michael Christopher, who's also on an incident response team located out here in Los Angeles near me, and finally, Samira Bouquet in San Francisco. Next slide, please, Victoria. Thank you. So the purpose of this slide is to really explain how it is that we handle, any third party or litigation matters. And I make that distinction. It's a bit of a misnomer when we call ourselves a cybersecurity litigation team, because we don't just handle matters in litigation. We handle any third party related claims. In fact, what we really try to do, to the extent possible, is keep matters out of the court. It's my experience, having practiced law for over 15, 16 years now, that as hard as you try to be efficient and keep costs to a minimum, and I do believe that we're reasonable and have reasonable rates, the nature of litigation, it's just expensive. Arbitration as well. Especially when you have discovery disputes, if you have a particularly aggressive plaintiff's attorney, which is not unusual, because they try to, for various reasons, throw work at you, in part to elevate the settlement value of the case. So as soon as a case is filed and you're in litigation, it tends to get fairly expensive fairly quickly. So one of the things that we try to do, to the extent that we can, is settle a dispute or matter prior to litigation. So I like to call ourselves, dispute resolution or conflict resolution, I suppose, as opposed to simply litigation. Much of our practice includes those third-party claims that are made against our clients with the threat of litigation, to the extent that we can't resolve them. And 9 times out of 10, we are able to resolve them. Sometimes it takes a bit of an education. We have to give a little bit of free discovery, so to speak, to plaintiff's counsel, inform plaintiff's counsel of the type of facts and discovery that he or she would otherwise get if we were in litigation, to try and convince that person that it's really not worth their time or effort to litigate this. Why don't we come to the table and iron out a resolution now? And it will have the added benefit of your client will receive compensation sooner than later. And we're usually successful at doing that. So to the extent that we have any claim that's pre-litigation, we work aggressively to try and resolve it. If it is in litigation, we look at all our different options, including, as Rich mentioned, the risk of liability or the risk of litigation resulting from a data breach has grown over time. I would say now it's great as it's ever been. And with data breach, with any incident that we've handled, to the extent that the impacted population, the people to whom we need to notify pursuant to state or federal law, if that notification population was comprised of employees, current and past, generally the prospect of receiving either a single plaintiff or class action complaint as a result of that incident and notification was pretty small. Generally, employees are understanding and don't rush to the courts to sue their employer. That's changed. Already 2 of the matters that we have been instigated by employees. One thing that we take a look at as soon as litigation is filed, or before it, to the extent that we are engaged before litigation, is whether or not the plaintiff or prospective plaintiff has agreed to arbitration. And that oftentimes is the case when it involves employees. And to the extent that we can navigate or push the claim into arbitration, it generally is to the benefit of our client for many reasons, but largely because it's just a more efficient process usually. So that's something that we take a look at. That's oftentimes not an available remedy or course to us, especially if the population of people being notified is not comprised of employees, but instead like customers, for example. Oftentimes they don't have arbitration agreements, or to the extent that they do, they wouldn't be applicable or binding in these types of class actions. And then finally, for the cases that are in litigation, again, we work to try and identify the most efficient resolution possible. And sometimes that does mean that we have to dig in our heels and go through some expensive discovery to try and educate the other side as to why the way in which they're valuing their claim is ludicrous, and you know, to get them to be more reasonable, to come to the table, to ultimately reach a settlement. That's where, you know, the vast majority of the claims are resolved, is by way of settlement. To the extent that we can dismiss an action, of course, we will try and do that. But the courts have increasingly become more and more plaintiffs friendly, especially now that we have various states, including California, for example, that have certain statutes such as the CCPA, CPRA, and CMIA that have that call for statutory damages in certain situations. So to the extent that you know, the plaintiff, whether it be single plaintiff or the class, can avail itself to a request of statutory damages and doesn't have to actually prove actual concrete damages that they sustain, it's much more likely that they will survive motion practice. And so that's changed over time, both with the fact that legislation state by state is changing, giving private rights of action to different plaintiffs, giving or calling for statutory damages in certain cases, but also the courts and judges just generally being more and more plaintiffs friendly and allowing these matters to proceed, you know, past the motion stage. So that unfortunately has meant that the plaintiffs bar has kind of woken up and has decided to bring more and more of these actions because they do see it as a moneymaker. I do want to address a question before we move to the next slide concerning what is the statute of limitations for a class action for a data breach incident. It's a good question. It really depends on the jurisdiction. It depends on the statute and the cause of action that's being alleged. Oftentimes, if there isn't a private right of action by way of statute, and in most jurisdictions there is not, the cause of action is pled as a simple negligence cause of action. And the allegations essentially are that our client was negligent in failing to properly secure the personal data that was entrusted to it. And so negligence, statute of limitations, again, varies state by state, but typically it's 5 or 6 years. Breach of contract oftentimes is alleged to the extent that you have like a patient who was received services from a particular healthcare provider and had a contractual relationship as a result of that treatment. Oftentimes those actions are pled as breach of contract. And so you have to look at the various jurisdictions to see what the statute of limitations is for that breach of contract. Unfortunately, in this space, we don't have the benefit of certain shorter statute of limitation periods like you do with various professional liability malpractice type suits. For example, in many different states, when you're dealing with doctors and malpractice claims, they have been very successful in limiting their liability by way of statute of limitations, in many cases to a year from the incident. So generally speaking, again, it's a matter of law and dependent on the jurisdiction, but generally speaking, it's not so short in this space. The purpose of this slide is again to kind of describe the different types of claims and matters in litigation that we handle. I'm going to start with the second bullet point first, alleged violations of breach notification statutes. So again, these are matters that essentially result from our client having been involved in a data breach. To the extent that they're involved in an incident that resulted in a population of people who were potentially impacted, whose data was potentially disclosed, and therefore had received notification. It used to be the case, like Rich said, that if it was below, say, 50 or 60,000 people that were being notified, we weren't too worried or concerned about the potential for litigation. Now, if we see or if we have a notification population of 50 or 60,000, almost regardless of the jurisdiction or industry, it's more likely than not that they will face litigation. So it's flip-flopped. That's how active the plaintiff's bar has become. And I've seen class actions for as little as or as few as 1,500 people. So they're really active. They really have woken up for many different reasons, including some that I mentioned earlier, including here, as I referenced, the CCPA, CMIA in California. California likes to be the leader in terms of new legislation. This practice area in general has its roots in 2003, or its genesis in 2003, when California became the first state to enact a breach notification statute. And now every state in the union, plus I think 4 jurisdictions, have various versions of that breach notification statute. And then again in 2018, California became the first state to enact privacy legislation with the CCPA, which then was amended slightly by the CPRA. And now, as Sarah mentioned earlier in the presentation, other states are following form. So what we see in California and the trends that we see in California, we can often expect to see throughout the nation. And the trend in California is that litigation is flying. It's being filed left and right, unfortunately. We handle data privacy legislation related litigation as well. So that doesn't necessarily result from a data breach. That can result from alleged violations of the TCPA, for example. That is a privacy related statute, and that's federal in nature. So it can really be filed anywhere. And we have a current one that we're handling that was filed in federal court in Florida. But in any event, we have vast experience with defending TCPA claims. I do, as well as Dave Udelson. And so we can handle those. As I mentioned earlier, Laura Balson and Ashley Euler both have vast experience with BIPA. If you're not familiar with BIPA, that's an Illinois statute that governs the privacy and disclosure of biometric data. And so we handle privacy-related litigation that results from those types of statutes that aren't necessarily data breach related. We also handle single plaintiff lawsuits that oftentimes result from fraudulent wire transfer. The most common wire transfer fraud and social engineering wire transfer frauds that result from real estate transactions. That seems to be the most prevalent. And I think the reason for that is, there are so many parties involved, and the threat actor only has to, go for the weakest link in the chain. So, you have a title company, you have the bank, you have, real estate agents on both sides. You have the seller himself or herself, the buyer himself or herself. You have lawyers for both the buyer and the seller. When you have so many people who are parties to a transaction, if only one party has their email compromised, and they never know that it's compromised, of course, because otherwise fraud wouldn't occur, the bad guys get in, intercept a conversation, pretend as though they are a legitimate actor, a legitimate party to the transaction, and trick somebody into sending the payment to the wrong person. So oftentimes that results in litigation to the extent that the parties aren't able to resolve it pre-litigation. And we bring our experience with respect to responding to incidents and working with forensic vendors on a regular basis to the table to help defend those matters by engaging with a forensic vendor to look at our client's email and broader network to try and determine whether or not there's any evidence that the compromise was to our client's systems. And to the extent that it wasn't, we had a pretty good defense against any potential liability that might lie with our client. Just as an example, sometimes we're able to discover based on the evidence that the compromise was of a different party, a co-defendant, and we're able to essentially point the finger to a certain extent at that party. Finally, just one last note before we take questions: regulatory investigations and resulting fines. We have seen those, as Rich mentioned, those are becoming more and more prevalent themselves for various reasons. And we have a lot of experience with the active regulators in this industry, in this landscape. And so if you're in the unfortunate circumstance where you face such an investigation and potential fine, please contact us. I mean, we can jump in, we can assist. Even if you already engaged with somebody else, it might be worth giving us a call just based on our experience to help you navigate, your way through the process.
So with Alan, if you don't mind, I'm going to ask a question that also relates to a question that was just asked by one of the members of the audience. So Ms. Rugnetta, I'm General Counsel for Corporation A. I am seeking excellent outside counsel for data privacy and information security matters. I don't know kind of what to do. What's my next step? If I want to find the best in the industry, who do I call and how do I engage them? And then also another question along with that is I also have been told in the industry that it may be helpful for me to have a cybersecurity technical firm, a technology firm, maybe a forensics or some other type of firm help me mitigate the risk of some sort of data security incident. Can you also help me with that if I'm General Counsel of Corporation A, and what steps do I take?
Sure, absolutely. Thanks for the question, Sean. We do have a lot of relationships with some great technical vendors. As I said earlier, a lot of people like to start with that gap analysis where we look at what laws apply to that particular company. A lot of companies do have obligations to perform enterprise-wide risk assessments and penetration tests. So oftentimes we will work with that. We'll introduce the vendor, sometimes under privilege, to have that performed. And that oftentimes does kind of demonstrate certain vulnerabilities on the technical side that kind of become part of that risk management plan and some of the services that we move forward with, in addition to some of those more privacy and compliance related services that we provide. So I think that absolutely makes sense for a lot of companies. In terms of how to engage us, pretty simple. We have a great breach response at constangy.com email that anyone can reach out to us. There's a couple different actually email listservs that are provided on the screen. Reach out to us. I think that our information will be included when we send these slides after the presentation as well. Happy to help and just even have an introductory call to talk through where an organization is and how we can assist.
So if I was on this, listening to this webinar and I heard each of you, I'm obviously very impressed because you are tremendous professionals, best in class in the industry. And I say, okay, I want to engage you. My understanding is that if I were to reach out to you, Ms. Rugnetta, and say, gosh, can I engage you? You would say, sure. And you would issue me probably a 2+ page letter that would call it a $0 retainer. So it won't cost that person any money up front. And then it's just a matter of agreeing upon, what work needs to be done and how best to do it. Is that right? And then in that process, you can also, if we needed to engage a forensics firm or a technology firm, we would do so on their behalf. So it'd be covered under the attorney-client privilege and the work product doctrine to make sure their confidential information remains confidential. Do I get it right? Is that a good summary?
You got it. Absolutely correct, Sean.
Oh, good. All right. But hey, you guys, I think we're at the top of the hour, and I really want to thank you. This was a tremendous webinar. You guys are obviously Well, I have to tell you, even if I try to play a different role, I am so proud to be your teammates and so glad to be able to call you teammates. You guys did an awesome job. Thank you for the great information. And if anybody listening has any questions, please feel free to send them our way. We'll make sure you get responses, and I believe the slide deck will also be provided to those who requested as well. Thank you very much.
Thank you all for joining us. We will now end the webinar.